All right, everybody, this is the little book on legal writing by Alan Dworsky, Chapter 8, Names, a Summary and Overview. First, refer to the parties in your case by their names unless their litigation roles are more persuasive. Using the names of parties is almost the clearest way to refer to them. Many lawyers use names in an office memo but switch to litigation roles when writing to a court, perhaps out of some mistaken sense that names aren't formal enough for such formal documents, yet no rule requires this switch. Generally stick with names when writing to a court. It's easy to forget who is the appellant or the plaintiff, much less defendant/respondent. Gotcha, so use names instead of the casual defendant/respondent. Next, pick a clear and persuasive name for a business or the government. When you represent a business, you may have some discretion in picking the name to use for it. For example, if your client's name is Ma's Cookies Consolidated Inc., you could refer to it as Ma's Cookies for short. Oh, look at that. You get to make your own nicknames. That's pretty fun. Next, pick a clear and persuasive name for a group of litigants. If you have more than 2 clients in one case, it's usually too cumbersome to continually name them all. You will have to come up with a generic name for the group. Try to do something more descriptive than plaintiffs or defendants. If possible, choose a name for the group that fits your persuasive strategy too. For example, suppose several buyers of houses in a project are suing a corporation that developed the project and sold them the houses. The lawyer representing the buyers might want to call them the homeowners and the corporation the developer, to emphasize the difference in size and power between the two sides. How interesting. Next, introduce short form names efficiently. When you mention a person for the first time, give the person's first and last name. After that, with no further explanation, switch to the last name alone. You know, that's pretty common, I think, but it's a good reminder, very good reminder to use that in case law. Don't use artificial titles for people. Don't use Mr., Mrs., or Miss in a memo or brief, even in the full form of a person's name, blah, blah, blah. You don't even need Mr. or Mrs. to convey the sex of a person. Convey the person's sex by using a pronoun shortly after the full name. Okay, that's good enough. Anyways, be careful using first names alone. Referring to your client by the first name alone will usually be stretching the humanizing tactic too far. It can backfire if it looks like an obvious play for sympathy. Look at that. You don't want to do that. Next, avoid initials. Just avoid initials. The whole, letter, capital letter. Avoid those. Next, refer to the parties in a cited case by their real life roles if possible. Interesting. When you talk about the facts of a case you've cited, often the best way to refer to the parties is by their real life roles, such as tenant or employer. Next, refer to the parties in a cited case by their names if you're going to use more than one quotation containing their names. The quotations containing the parties' names you use from a case, the clumsier it is to refer to the parties by their roles. You can prepare for that problem in one of several ways. You can tell who was who when you first give the facts of the case. You guys, this is too dense. You're gonna have to Google it. Anyways, I'm gonna repeat it again. Refer to parties in a cited case by their names if you're going to use more than one quotation containing their names. I don't know, you're just gonna have to Google that one because that one is a little tough. Next, a business or institution is, quote unquote, it. This is the same advice I gave regarding courts in the previous chapter. Business entities such as corporations and partnerships and institutions such as universities and government agencies take singular pronouns. Good stuff. You guys, we're almost at the end of this. Look at that, we did it. Put legal arguments into the mouths of the parties, not their lawyers. We all know legal arguments are made not by the parties themselves, but by their lawyers. Nonetheless, it is traditional and efficient to speak of arguments as if they had been made by the parties. Thus, in an office memo, if you are anticipating the argument on the other side, say IBM will argue, not counsel for IBM will argue. Similarly, in a brief, say IBM argues, not counsel for IBM argues, or opposing counsel argues. Just say the person. And that's pretty smart because then it also it just makes it easier to tell the story, right? If you say, Sally ran over Jimmy with her car, not Sally's opposing counsel ran over Jimmy's opposing counsel. Anyways, that was a terrible example. Remember to kiss that like button with your finger and kiss that subscribe button with your finger and get ready for other videos. All right, bye-bye. Oh yeah, and the Patreon page for Miyakizilla. If you want to see more content like this, remember, go to the Patreon page for Miyakizilla and become a member. Thank you for being a member to those people who are members. All right, bye-bye-bye. If you're an independent and you care about being represented, even more so if you're frustrated and you feel like you're not represented, the whole point of this project, the whole point of this content is to help independents feel like they've got a voice, feel like they've got somebody fighting for them. And so that's what this content's about. If you're interested in supporting this, go to the patreon.com/Miyakizilla Patreon page and consider supporting us for $2 a month. That's all. All right, thank you very much. Bye.